Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Did I bring it? Am I being enthusiastic enough for YouTube? Um, it's a holiday weekend. I got I got two more videos to knock out, and I'm done. Done. All right. We have a question from YouTube user. I hope I pronounced it correctly. Chirazi. And it's more of a statement than a question, but I thought it was worth addressing. So Chirazi says, it is difficult to find attorneys who will represent you during the EEOC process. I responded, it can be, but it's worth the effort in my opinion. Let me expand on that. There's a whole bunch of attorneys nationwide, I hear it all the time, who don't want to handle the EEOC for you. They don't think it has value. Here's why they're wrong. Overwhelmingly, our cases resolve at the agency level. Overwhelmingly. And that is for a variety of reasons. But first and foremost, it keeps you from you're not creating public documents. You're not on a federal docket with your case showing up on Google for every job for the rest of your life that you apply for to see. So there's a huge advantage there. And not to be cynical, but by the same token, when your case isn't out there, if you want to sell your silence, your employer can still buy your silence, right? I'm not saying you do. I don't know if you do or not, but some of you do. I'm not telling you should or shouldn't. What I'm telling you is you maybe want to keep this thing quiet. If you want a quiet case, your claim, which most claimants do, frankly, right? That's one of the beauties of the system is that you can, if you play your cards right, to some extent. If that's what you want, you've got every reason to resolve that case at the EEOC agency level before it goes on to federal court. And there's going to be some attorneys who say, yeah, but Vince, the case might be worth a little bit less than settlement at the EEOC. Maybe. Every case is different. Maybe. I don't think that I'm convinced about that because at the EEOC level, again, that employer can still purchase your silence. Also, that employer hasn't spent as much on legal fees, so often they'll find that extra money that they know they're going to spend in legal fees later if your case goes on to federal litigation, and they'll put it in the settlement because the settlement's a sure thing, right? If you accept the settlement, they know they're done. If they fight the litigation, they could lose, and they could lose big. So often, the smart employer will say, hey, we don't know if you're interested in this, but here's a settlement offer. It's going to come with a confidentiality agreement, which, hey, listen, the world's changing. Those may or may not be legal in different places, depending on how you read certain laws and certain precedents that are being developed. So this is all in flux, right? This is May 26th of 2023. And 3 months from now, I might be making a video saying, hey, no more confidentiality in settlement agreements. That, right? Things are in flux right now. But where it stands right now today, an attorney who's saying, we don't do EEOC, one of the huge reasons why that doesn't make sense is because one of the most valuable things the employer wants is the confidentiality agreement, right? It doesn't make sense. Fundamentally, it doesn't make sense. Also, does the EEOC suck on a routine basis? Yeah, but it's still some free discovery, and it's still a place to fight the employer in a round one scenario, right? Like, you can't lose. Realistically speaking, you can't really lose at the EEOC. You can get the result you want. You can have discussions about results you may or may not want in terms of settlement, but you can't really lose. You're always going to have the option to proceed, whether it's to federal court, maybe state court, maybe arbitration, wherever you might end up going. So it's kind of an interesting place to start, right? You get to go a couple rounds, at least the first round, in a venue where you can't really lose. Also, during the entirety of the EEOC proceeding, guess what? You're creating documents that could potentially show up later in the case. You're also creating documents that could control what can and cannot be brought up as claims during a federal litigation. All that sounds pretty important, doesn't it? Right? Like I've had this conversation many times. I go to conferences and I'll talk to people like, no, we don't handle EEOC. We only want Fed lit. We only want state court lit. And I'm, really? Why? Like that's a tool in the toolbox. It's a good one. It's a powerful one. It's like going nuclear, right? You're going to war when you go to Fed lit, right? That's make a federal matter of it, right? It's a saying, for God's sakes. It's a big move. But it's not the only move. And I don't really understand why you would play a very complex game, right? Workplace discrimination claims, workplace sexual harassment claims, these are not simple litigation. They're called, by definition, complex litigation, right? And so you should treat it like complex litigation, right? Like if you have a personal injury case, generally speaking, 99 times out of 100, in almost any jurisdiction, you just go file in court. Because you always know basically what's going to happen. You might win, you might lose, but you know the path. You know what's going to happen. This is complex lit. This is basically 3D chess, right? I mean, I don't want to go meme about it, but like it's a big brain game. Like you're protecting someone's well-being who's been horribly harmed, and you're treating their well-being as a resource that you need to take care of to get them over the finish line, right? Because these cases are not easy. And being in the EEOC lets you operate for a period of time in a lower harm environment for your client while maintaining things that your enemy might want from you, right? If you're selling eggs and your worst enemy wants to buy eggs, you might sell your worst enemy eggs. You might want to sell the eggs, right? But if you smash all the eggs, you don't even have the choice anymore. You can't sell the eggs. You can't tell your enemy you're not going to sell the eggs. You smashed all the eggs. The eggs in this scenario are the confidentiality, among other things, frankly. And when you go straight to Fed lit, you skip over the EEOC process entirely, and that person's not represented, so not much is necessarily going to happen in the EEOC process, you are squandering a variety of tactical options. You are wasting time. And you're wasting time, again, where your client's well-being could be conserved. That matters. That matters. So, Shirazi, I get it. You're frustrated. Employment attorneys are the worst. We are the worst. We are. Me included. I look in the mirror, actively hate myself. That being said, it's worth it. It's worth it if you can find an attorney to represent you in the EEOC. There are so many benefits, and the attorneys who will represent you in the EEOC generally are going to understand that, are going to be approaching this game from all angles, right? That's what you need. You need, okay, today this happened. Maybe we love that, maybe we don't, but we need to think about the consequences and the other avenues of approach, right? That's what happens at any given time something happens in a case, if you're smart about it. Okay, this happened. Now, I got to think about it for a couple hours. That's what should be happening in your counsel's brain. This happened. I don't love that. Well, what are my other options? How can I work around it? How can I make it work for me? Well, is that witness, can I attack that witness? Is there something I can do that with? Maybe. Should I be adding that witness as a personal defendant under 1983? You know, like, oh, that guy's going to mess up my case as a witness? Well, can I get him? Right? There's a lot you can do, you know? And so you shouldn't be giving up the runway to do that, which is the EEOC. As annoying and often useless as they can be, it's runway to have a fight where you can conserve the client's well-being. And also, it benefits the employer if they can settle at the EEOC level in a variety of ways. So, listen, I'm going long here. Keep at it. That's what I'm saying, which is easy for me to say. Keep at it. If this was helpful, like, subscribe, share, comment down below. Helps me to help more people just like you. And I will be cheering for you. Oh, remember, everybody works. Almost nobody wins. Almost everybody works. Not everybody wins. Take care.